Hi guys, criminal defense attorney Ryan Pacyga, and today I wanted to talk to you about the difference between not guilty by reason of insanity versus being incompetent. So let's say someone's going through some mental problems where they're maybe delusional or paranoid and things like that, and they get charged with a crime. There's two different things the courts can do about that if the person is really struggling with, some major mental health issues. The first one is to determine whether the person can even understand what's happening in court. And that's not so an insanity defense. What that really means is, are they competent to proceed? So if the person has a hard time communicating with their lawyer or they're not making sense, and the court is concerned that the defendant isn't understanding maybe what's happening in court or can't assist their lawyers in the preparation of a defense, or wouldn't be able to testify because they just can't appreciate really what's happening in court at the time, then the court can have that person evaluated, and either the defense lawyer can bring a motion and ask the judge to do that, the prosecutor can do it, or the court can do it on its own in most states. And then a forensic, psychiatric, or psychological evaluation will take place. And sometimes there's a battle of experts. Sometimes the state's expert says the person's fine to go through with court. They totally understand what's happening. And maybe a defense expert has a different view on that, or vice versa. And then the court will have a hearing and determine whether or not the court case needs to be paused at that point in time, and then try to restore the person to what's called competency so that they can understand what's happening in court. And then the court process would continue on after the person has been restored, usually with some psychological or psychiatric help, as well as oftentimes medications and therapy and those sorts of things. Sometimes that can take months or even years to take place, but it's not like the case goes away at that point in time. It's just pause until the person can get mentally better and go from there. The other part of it is not guilty by way of insanity. Now, that's a defense to a crime, whether or not you can understand what's happening in court at the time. So let's say someone's been restored mentally for court, or the court determines that they're able to understand what's happening in court and they've never had to been restored. The question is, looking back at the time of the alleged crime, was the person insane, if you will, at the time of the crime, so that they couldn't appreciate the nature of the act that was criminal, in other words. And that's a big battle. That's a tough defense to raise. I have prevailed on it for client, but every case is unique that way, and that takes experts also looking back at the person's life at the time that the crime allegedly occurred and what was going on, enough to either raise the issue for a judge or jury to determine whether they should not be responsible for the crime, because of the defense of insanity is the common word that's used in that. And again, every state's a little bit different. But if you have questions about competency or the insanity defense, you can always reach out. You can find me at arrestedmn.com or call me at 612-339-5844. Thanks.